Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I'm VP Moolman from Maserumule, and in today's episode we will unpack what if an employee hands in a suspect medical certificate. When may an employer query the validity thereof? Now colleagues, as we know, abuse of sick leave is a real issue and it does impact on production, quality, as well as the relationships in the workplace. We know that when an employee is absent due to illness, under certain circumstances, they need to submit a medical certificate. The Basic Conditions of Employment Act states that a medical certificate must be submitted if the employee has been absent from work for more than 2 consecutive days or on more than 2 occasions during an 8-week period. The Basic Conditions of Employment Act further requires that this medical certificate must be issued and signed by a medical practitioner or any other person who is certified to diagnose and treat patients, and importantly, who is registered with a professional council established by an Act of Parliament. Now, it is so that many employers receive medical certificates issued by bogus doctors or doctors who issued the certificate without any form of physical examination, which does call into question the authenticity and credibility of certain medical certificates submitted. So, the question that arises is whether employers should accept medical certificates without asking any questions, or do they have the legal right to request more information about the diagnosed illness to fairly and knowledgeably assess the justification for the absence. Now, answering this question, recently a matter proceeded to the Labour Court where this point was specifically discussed. The matter I'm referring to is the EpiBiz versus CCMA and others, and the employee in this matter was called to a disciplinary hearing in which she was found not guilty. After her hearing, obviously had to come back to work, she failed to return to work and handed in a medical certificate, or rather certificates, which booked her off for a long period. The first certificate booked her off from the 15th to the 30th of August, more than 2 weeks. The second certificate booked her off from the 28th of August to the 30th of September, more than a month. The third certificate booked her off from 29 September to 29 October, again a month. And the final certificate booked her off from 28 October until the 28th of November, again another month. Now importantly, or interestingly, out of these 4 certificates, only one of them stated that the reason for illness, or the nature of illness, the reason for incapacity is stress and insomnia. All the other certificates recorded as the nature of illness consultation, the actual word consultation as the nature of illness, which is strange. So following the employee's lengthy and apparently unknown absence from work, an incapacity meeting was proposed by the employer in order to address the employee's absence. This proposal was responded to in writing by the employee's legal representative, who had indicated that the employee was not emotionally and psychologically ready to return to her place of work due to post-traumatic stress disorder arising from the disciplinary action against her. This, colleagues, was apparently not supported by any medical confirmation or medical certificate. As I've mentioned earlier, there was only one certificate that recorded stress and insomnia as the reason for absence. The rest all refer to consultation. So, considering all of this, the employer then issued a letter to the employee in which she was informed that her services are terminated. Now, this dismissal was challenged by the employee at the CCMA, and the CCMA found that the dismissal was procedurally and substantively unfair. The Commissioner found that, based on the medical certificate, and there was also a social worker's report, the employer was aware of the employee's condition and ought to have been prudent and considerate in approaching the employee's situation. The Commissioner concluded that the employer was hasty in terminating the relationship, and thereby it rendered her dismissal procedurally and substantively unfair. The employer was unhappy with this outcome, so they challenged this award at the Labour Court. Now, considering the matter on review, the Labour Court noted that in the arbitration, uncontroverted evidence was presented by the employer that it made various attempts to request the employee to return to work. The evidence established that it was the employee and her representative who had frustrated the employer's attempts to properly ascertain the real reasons for the employee's prolonged absence from work. The employer wanted clarity on the nature of the illness, called consultation. The court pointed out that the employee herself could not explain her illness recorded in the medical certificates. And furthermore, the treating doctor did not depose to an affidavit to substantiate the nature of illness that was recorded, and he or she was not called by the employee to give oral evidence in the arbitration proceedings. Colleagues, the court also in this matter confirmed that it is trite law that a medical certificate or sick note from a treating medical practitioner remains hearsay evidence if the said certificate is not accompanied by an affidavit from the said doctor. And this principle has been made clear by the Labour Appeal Court in previous matters. Now, the Labour Court concluded that the employer was prevented by the employee and the employee's representative to comply with procedural requirements, and the court concluded that the arbitrator's finding is not one a reasonable decision maker ought to have reached, having properly considered the evidence presented to him. Now, with regards to reliance on unsubstantiated medical certificates, the court pointed out the following. The court said that the integrity of medical certificates or sick notes cannot always be guaranteed, as in certain instances, a critical perusal of the certificate or the medical certificate demonstrates no nature of illness but symptoms that do not render an employee incapacitated to perform work or follow disciplinary proceedings. The court said that at times, medical certificates or sick notes can be fraudulent. Medical doctors must always be conscious of their civic duty to the society and the rule of law. The court pointed out that doctors must always remain conscious of their Hippocratic oath and routinely stay true to its terms and spirits. It is not the role of a medical doctor to be an accomplice in an enterprise calculated to deceive and defraud the employer. By way of example, the court referred to the matter of Woolworths versus the CCMA and also the recent SARS matter, where in the Woolies case, the employee handed in a medical certificate which declared him too ill to attend work. However, on that same day, the employee said he was too ill to work. He was out enjoying a game of rugby. His dismissal was found to be substantively fair based on the gross dishonesty committed by the employee. In the SARS matter, which I discussed in a video earlier this year, same thing happened. Employee submitted a medical certificate indicating that the nature of his illness was absence due to a medical condition. However, the facts revealed that during this period of illness, he attended a protest action where he sang and clapped hands in support of such action. The court concluded that the probabilities were overwhelming that the employee was not sick, and in fact he was absent in order to avail himself for the protest action. If he was able to clap hands and sing, it must follow that he would have been able to perform his contractual duties. Now, considering the outcome in the matter we have discussed, it is not entirely unjust for employers to approach vague or unsupported medical notes with some skepticism. It's within an employer's rights to ask for clarification on the illness or injury to ensure the employee genuinely could not work. If needed, further confirmation like an affidavit from a medical professional or sworn evidence might be necessary. Colleagues, that brings us to the end of this week's episode. Thank you for joining us. We hope you found our discussion informative. As I always say, if you have any questions or comments, we would love to hear from you. You can find us on social media or you can email me at vapia@massconsulting.co.za. Until next time, bye-bye.